A judge allows a lawsuit between the Petitos and Brian Laundrie's family to move forward. Plus, a murder conviction overturned. Will Tex McIver get a new trial for the death of his wife? And after 43 days on the run, a suspected killer is found and caught by U.S. Marshals in a different country. But first,
she points her fingers at everyone she can possibly name, including people that are thousands of miles away in Minnesota.
And I would posit the question, why? Why would she murder Savannah?
Closing arguments are presented in the Missouri case against Rebecca Ruud, a mother charged with killing and burning the body of her 16-year-old daughter. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmire. Closing arguments are presented in Missouri versus Rebecca Ruud as she faces first-degree murder for the death of her 16-year-old daughter, Savannah Leckie. Ruud is accused of killing and burning the body of her daughter in Ozark County in 2017. Savannah was adopted at birth by Tamil Leckie Montague and David Leckie, a couple who divorced shortly before Savannah's death. Savannah, who had special needs, began struggling with behavioral problems as a teen while still with her adopted mother. Leckie Montague and Ruud agreed to have Savannah move back in with her biological mother and her boyfriend, Robert Pete. 11 months later, Ruud reported her daughter missing. Prosecutors say Ruud abused Savannah and that she and Pete eventually killed her and burned her body. Investigators searched their Ozark County farm and found bone fragments and teeth in a burn pile. Pete, who is also charged in Savannah's murder, testified against Ruud. Prosecutors presented several witnesses, including local law enforcement, volunteer firefighters, neighbors, and friends of Ruud's and former inmates who she allegedly confessed to crimes. After 3 days of testimony being presented solely before a judge, attorneys presented their closing arguments Thursday. Prosecutors posed the question, if the defendant's story is true, why did she lead people to believe Savannah was still alive despite admitting to burning her body?
How do we know the defendant killed Savannah? Defendant destroyed the body. You know this from State's Exhibit number 17. That was the teeth and the jawbone recovered from the burn pile. There was barely anything left of Savannah Leckie, enough to fit into a bag. That's how terrible the defendant's treatment of Savannah Leckie was. Law enforcement officers from several agencies, Ozark County Sheriff's Office, Baxter County, Arkansas Sheriff's Office, Highway Patrol, civilians, firefighters, perhaps 100 people are out there on this 81-acre farm, scouring it, looking for Savannah, believing that Savannah had run away. She points her fingers at everyone she can possibly name, including people that are thousands of miles away in Minnesota, as being involved in Savannah's disappearance, despite knowing where Savannah was in the burn pile because she placed her there. She killed her and placed her there.
Throughout the case, Ruud's attorneys argued she didn't kill her daughter, but admits to burning her body only after Savannah killed herself. In their closing argument, they argue the state didn't prove a murder took place at all.
The state kind of posits the question of why. Why would Reba destroy Savannah's body if nothing sinister or nothing bad happened there? And I would posit the question, why? Why would she murder Savannah? What was going so wrong there that she would have progressed suddenly to murder? The evidence of murder that the state wants to present is that the destruction of the body must mean murder. There's a whole lot of other reasons as to why Savannah ended up dying. And unlike the state, ours is supported by medical evidence. It's a stretch, and it certainly goes against everything that we as lawyers learn in law school. We learn that we have to lay foundations, that we can't just jump to certain things, that simply because someone says, well, this must have been a murder, there has to be more. There has to be more evidence to support the actual murder. What the state does have, the state has evidence to show that they're for abandonment of a corpse. The state can absolutely prove that Reba burned Savannah's body. But that's all they can prove.
The judge is expected to announce his verdict by July 15th. Joining us today is legal analyst Matt Mangino and co-host Terri Austin. Matt, is the defense right? Did the prosecution not prove their case? To you, are there any issues that you think the judge will have in deciding this case?
Well, I think that they drove home the point that the prosecution has the responsibility to prove beyond a reasonable doubt that there's been a murder. we know, and they candidly admit that she's responsible for destroying Savannah's body, after her death. But, has the prosecution met their burden of proof with regard to proving that there was a murder? All that they have are jailhouse informants, and those are not the most reliable witnesses when it comes to trying to prove your case. In this instance, to a judge, not even a jury, just a judge. So I think they put a plausible defense forward.
All right, Terry, let's ask on the other side of this coin. Why do you think the prosecution proved their case and the defense didn't poke holes in it?
Well, I have to say, if this had been before a jury, I think the prosecution might have a good chance of winning for the reasons that Matt just stated. But this is before the judge, and a judge is going to listen to all of this evidence and determine whether or not the prosecution actually met its burden. I think what the prosecution did well is to demonstrate that there's no question the body was burned, and she tried to hide that. She said that she was missing. She basically tampered with the evidence by burning the body. That's consciousness of guilt. And so the judge can consider all of that, but he may very well, hold the prosecution to that very high standard of beyond a reasonable doubt. And that's why it was a great idea to have this before a judge.
Absolutely. Well, we'll see how this plays out. What is it? July 15th, we'll get a verdict, and we'll not going to be like a jury trial verdict, but we'll make sure we'll get it to you here at Law and Crime Daily. Still ahead on Law and Crime Daily, a former prominent Atlanta attorney's murder conviction is overturned. What that means for Tex McIver's case in the 2016 shooting death of his wife. But first, following weeks on the run, a suspected killer is captured. Now, Caitlin Armstrong faces deportation back to the U.S. after being caught in Costa Rica. Welcome back. After weeks on the run, a Texas woman accused of fatally shooting an elite cyclist has been captured in Costa Rica, according to U.S. Marshals. 34-year-old Caitlin Marie Armstrong is accused of killing Anna Wilson in Texas, May 11th. Armstrong was in a relationship with and living with her boyfriend, Colin Strickland. At the time, Strickland said he had dated Wilson last year while he and Armstrong were separated. Investigators believe the shooting may have been a violent act of romantic jealousy. Police issued a warrant for Armstrong days after the shooting, but she wasn't found until this past Wednesday after 43 days. U.S. Marshals arrested her at a hotel in Costa Rica. Investigators previously said Armstrong used a fake passport to fly from Newark to San Jose on May 18th. But Costa Rican officials say her passport was real, it just didn't match her identity. Armstrong will be deported back to the U.S. to face charges, but there is no specific date when she will return. Terry, the first question a judge will have to determine when Armstrong is in the court is bail. Do you think she will get any or be held until trial?
I think she's going to be held for trial because I would not, if I were the judge, grant bail under these circumstances. One of the main considerations for bail is whether or not it's a flight risk. Here, we already know that she went after this individual to Costa Rica. She flew from Newark and, she had a warrant for her arrest and she wasn't found until 6 weeks later. So I think that, she was using someone else's passport. And the fact is, with that type of situation, the judge is probably going to deny bail. Whether she's a danger to others, it remains to be seen. But why take any chances that she'll, risk flight again? And I think the judge is going to keep her in jail.
All right, Matt, I'm going to be a public defender and lay on the sideline. I'm going to let you make the bail arguments. I'm going to take a break for it. So what are the defense's arguments for why bail should not be set in a case like this where, as Terry said, there's so many strong arguments?
Well, the first thing that I would argue is, and I'm not exactly sure, but if she has no criminal history, you want to make that clear to the court. Does she have ties to the community where she's going to live? Has she had any problems in the past with regard to being evasive or leaving town unexpectedly? I mean, quite frankly, I want to zealously represent my clients in every case, but this is going to be a tough sell. As Terry said, I mean, she left the country with this homicide charge over her head. And she did it in a way in which she used a passport that didn't belong to her. I mean, even Natalie Bailey would have a tough time with this argument for bail.
Yeah, we'll see what happens, though, when that eventually does come, because there's going to be a bail argument made in this case. Well, thank you both for your inputs. Coming up on Law and Crime Daily, a murder conviction overturned. We're looking at the case of Tex McIver, who was charged and convicted for the death of his wife. Plus, a lawsuit between the Petito family and the Laundrie family is moving forward. Details on the denial of a motion to dismiss. Welcome back. In Georgia, a former Atlanta lawyer is granted a new trial as Claude Tex McIver's murder conviction is overturned. McIver was convicted in the shooting death of his wife, Diane. The couple was driving home from a party with a friend when McIver allegedly shot his wife through the front seat as he sat in the back seat of their SUV. During the trial, there was testimony that McIver shot the gun as a result of being startled awake, and that he suffered from a sleep disorder which could cause involuntary movements. He was convicted of murder and sentenced to life in prison. The state Supreme Court this week ruled jurors should have been allowed to consider a misdemeanor involuntary manslaughter charge, not only murder. The judge said the reason they should have had that option was because the evidence of McIver's guilt was not strong enough. He argues from evidence during the trial, the jury could have concluded he didn't intentionally shoot his wife, but that it was an accident. Terri, with charges dismissed from the trial court and now charges overturned from the Supreme Court, if there's a retrial, what would the charges be?
You know, the prosecution is thinking about that as we speak, and what she's trying to consider is what will the evidence show? She could still charge with a murder charge, not the malice murder, but the felony murder. But she has been instructed by the court that she should have put in and included a lesser charge. So we'll see if she decides to go for the, home run here, or if she just puts in the lesser charge. And there's another option, Brian. She could just not bring any charges at all whatsoever. One of the things that the Supreme Court said was, look, there wasn't a lot of evidence here that this was murder. And so we might even see that they just decide to pass altogether. And he's already served over 4 years. And if, in fact, he were convicted of anything else, he's probably served most of his time. So she may just pass.
Yeah, Matt, from what the judge is saying, are they saying that McIver should not have been found guilty of the murder charges he was convicted of based on the reasoning? And how does that affect whether or not we have a retrial?
Well, I think, as I understand the court's decision, what they alluded to was that the malice murder charge he was acquitted of. So there wasn't sufficient evidence that proved malice murder. He was convicted of felony murder, but they're saying that because of the jury's decision in this case, they should have had the option to review the involuntary manslaughter charge as well, and that not instructing the jury on that lesser included offense, that they didn't have an opportunity to consider it. And that was prejudicial to the defendant in this case, and he's entitled to a new trial.
All right, we'll keep eyes on this case because whether it's a new trial or no trial at all, that would be a massive breaking news considering how this case went down when we first followed it. Well, in California, prosecutors claim the alleged killer of rapper Nipsey Hussle came strapped and loaded with 2 guns and a plan to shoot him dead, as closing arguments were presented in the trial of Eric Holder Jr. Thursday. After 3 years of delays, defendant Eric Holder Jr. faced his jury trial over the last 2 weeks on charges of first-degree murder, attempted murder, and assault with a deadly weapon. Holder was arrested in April of 2019, less than a week after he allegedly shot Nipsey Hussle in front of the rapper's Marathon clothing store. Police say a dispute broke out between the 2 men after Hussle accused Holder of being a snitch. Investigators say Holder left the store, then returned with 2 weapons and shot Nipsey Hussle. A medical examiner found the rapper was shot at least 10 times, with the bullets piercing his lungs and severing his spinal cord. A witness alleges Holder told Nipsey Hussle after the shots were fired, quote, "You're through." The judge previously ruled there would be limited media coverage allowed on the trial, only allowing cameras for the opening statements and closing arguments. Prosecutors presented their closing arguments Thursday, telling the jury the killing was planned.
But as she turned that block back on the Slauson, she saw him manipulating what she saw for the first time that day, the black semi-automatic handgun. Looked like he was putting bullets in the magazine. And she, alarmed that he was going to shoot either at her or out the car, she said, "You're not about to shoot from my car." And he just kind of shrugs it off and puts the gun away. He was already planning to kill Nipsey Hussle, ladies and gentlemen. That's planning. That's premeditation and deliberation. That's thinking about it before you do it. He puts on his shirt for the first time that day. Why? because he knows he's going back. He's already planning that. There's no reason for him to walk around all day with no shirt on, get in the car, and then all of a sudden put the shirt on in the car. He's putting that shirt on to give him whatever element of surprise he can get.
Holder's attorneys say he admits to shooting Nipsey Hussle, but that he denies it was premeditated. On the next episode of Law and Crime Daily, hear from Holder's defense attorney as he presents his closing argument. When we come back, a judge rules on a motion to dismiss, as a civil lawsuit stemming from the death of Gabby Petito at the hands of Brian Laundrie can move forward. Welcome back to Law and Crime Daily. Headed now to South Carolina, where Tiger King star Doc Antle has been indicted on 10 new charges just days after being released from jail. The owner of Myrtle Beach Safari is back in the attention of federal law enforcement. The Netflix star and 3 of his employees now face wildlife trafficking and money laundering charges. The 4 allegedly violated 2 federal wildlife statutes, the Lacey Act and Endangered Species Act, by creating fake records involving the movement of endangered animals. If convicted, they will be forced to forfeit all illegally acquired animals and any vehicles used while moving them. Antle was just granted $250,000 bond and released Tuesday after spending 3 weeks in jail for federal money laundering charges. Antle faces a possible 25-year prison sentence and faces separate animal trafficking charges in Virginia. And in Florida, a judge has ruled a lawsuit brought about by Gabby Petito's parents against Brian Laundrie's parents will move forward. Gabby's disappearance last summer gripped the nation after she and her boyfriend Brian ventured out on a cross-country-wide trip in their converted van. Gabby was found dead in Wyoming, killed by strangulation, according to investigators. After returning home alone, Brian went missing. His body was found weeks later, dead by suicide. In March, the Petitos filed a lawsuit against the Laundries, arguing they knew Brian had killed Gabby, and then, a month later, added to their complaint, alleging intentional infliction of emotional distress. The Laundries moved to dismiss. On Thursday, a judge announced he will allow the lawsuit to proceed. The Laundries' lawyer argued his clients were acting within their constitutional rights to remain silent throughout the investigation. A jury trial for the lawsuit is scheduled for August of next year. So, Matt, how can the Petito family prove what the Laundries may have known from a private conversation about Gabby's death? Isn't that going to make this case an uphill battle for them?
Well, they allege that the Laundries knew about Gabby's death as early as August 28th, before Brian Laundrie even came back to town. But that's only an allegation, and I'm sure the Petitos are going to deny that allegation. But what it does is it opens the door to depose the Petitos and to other people, and to ask them questions under oath about what they knew, when they knew it, and about their lawyer's statement that they were hoping for the return of Gabby. All which leads to this issue of emotional distress. And that's what they're alleging in their complaint.
Yeah. Now, Terri, you previously thought the judge would deny the motion to dismiss. Why do you think the judge allowed the case to proceed to trial?
You know, it's very difficult to win a motion to dismiss, and you can make this type of motion for a bunch of reasons. Statute of limitations, you can say the court doesn't have jurisdiction, you can say the plaintiff doesn't have standing, but here, what the motion was basically saying, look, there's not a cause of action here. Even with the facts, it doesn't support this cause of action, intentional infliction of emotional distress. And so the attempt was to get that case dismissed. I think the judge prefers to let it go to a jury. And in order to prove it, obviously, you have to have an intentional or reckless act. You have to have outrageous conduct that causes this severe emotional harm. The judge prefers to let a jury decide those issues and decided to let the case go forward.
Well, we will obviously be following that case as it does. Matt, Terri, thank you. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.